matters, but they were nearly 10 years ago in 2007. We would ask the court to consider a $5,000 10% bond.
Your Honor, the
With the
people
tether.
who would object to any reduction in bond, particularly a bond that low, he has another case pending as well, misdemeanor disorderly conduct. What he's charged with here involves an assault, potentially great bodily harm, less than murder, where
The court will continue the bond. I'll refer to the practice committee and bond recommendation.
Yes, Your Honor. Yes.
Luther is his brother. His name is
William.
Ms. Denmark, what you need done?
I got it.
Okay.
You're right, Dave.
Yeah, we'll do that.
They're going to fall out of them. I'll get my phone.
Yeah. I do have one more question, Your Honor. Oh, I know.
Okay, we're back on the record. People versus Brown and Williams.
Your Honor, this is a part of people's proposed exhibit number 17. I'm going to ask her if she's familiar with the item in terms of, is this the format that they'll deliver weekly?
Yes.
And that's part of your responsibility of your team to just deliver the medication.
Yes.
That was it?
Is that it? That's it.
Cross-examination?
Thank you.
Ms. McCall, the judge asked you if you have the ability to remove the child from the home, and I believe that you indicated no, you don't, correct?
Correct.
However, as a therapist, not only do you have the ability to initiate hospital proceedings for Ms. Minor if you thought that they were necessary, you have that ability, correct?
Correct.
But you also have the duty to do so if you believe that she poses a substantial risk of harm to herself or others, correct?
Correct.
And you didn't do that, correct?
Correct.
At any point from May of 2015 until the death of Aaron Minor was discovered, you never sought to have her hospitalized, correct?
Correct.
And that's because you didn't have a reasonable belief that she was a substantial risk of harm to herself or others, correct?
Correct.
Okay. So at no time did you ever have that belief?
Correct.
All right. Now, you testified in June of this year under an investigative subpoena, correct?
Correct.
And I wasn't there, but the prosecutor was there and Sergeant Mackey was there, correct?
Correct.
And you told them that you knew Aaron Minor, you saw him on many occasions, correct?
Correct.
And you never saw any signs of abuse, correct?
Correct.
Never saw any signs of neglect, correct?
Correct.
Always looked normal, fed, and appropriately disciplined, correct?
Correct.
Never saw any signs of bruises.
Correct.
He was always happy.
Correct.
In this particular case, you said the reason you called and initiated the original complaint on April 20th is because you believed there was a possibility that Deanna Minor was not taking her medication, correct?
Correct.
All right. And that belief was based on the fact that Deanna Minor said to you or said to somebody on your staff that she wasn't taking her medication, correct?
Correct.
Now, Deanna Minor said a lot of things that weren't necessarily true, did she not?
Correct.
And you never saw a drawer full of medication in her home, did you?
I did not.
Okay. And you never saw the pills in her home, correct?
Correct.
And did anyone document in the records that they saw lots and lots of pills?
I don't recall that.
Okay. And so your belief that there's a possibility that Deanna Minor may not be taking her medication, correct?
Correct.
And that was really the only basis for your call on April 20th, correct?
And her behaviors.
And her behaviors.
Correct.
However, her behaviors did not rise to the level of you being concerned that she was a substantial risk of harm to herself or Aaron Minor, correct?
Correct.
She had some funky behaviors, correct?
I wouldn't necessarily say funky, but from a mental health standpoint, she was delusional, very assertive, very aggressive, and so that's why we made the call.
Okay.
Yeah.
And that goes along with, remember telling the judge that's almost like what Elaina Brown told you. She could tell there was something right, but there was, she didn't have any authority to do anything based on that, correct?
Correct.
All right. And that's the same position you were in, correct?
Correct.
All right. Now, when you called, you didn't necessarily know she wasn't taking her medication, but you believe there's a chance that she may not be taking her medication.
Correct.
All right. And if there was a chance, if she wasn't taking her medication, if that chance existed, it's your belief that she might be in a position not to take care of her child, correct?
Correct.
All right. And again, if she weren't taking her medication, and that might lead to the possibility of her not being able to take care of her child, but you didn't ever see anything that led you to believe that that was taking place, correct?
Correct.
In fact, didn't you tell Ms. Goldfarb that you didn't think anything was wrong with Aaron Minor and Deanna Minor and their interaction until after the fact of his death?
I don't recall that.
If I showed you a copy of your transcript, would that refresh your recollection? Page 34, counsel. May I approach? It's the bottom of 34 and the top of 35.
Right here.
Yeah, just hold it to yourself.
Is this you or John? It says John at the top.
Well, will you just read it? right now, if that refreshes your recollection.
Yeah. Yes.
Okay. And so, does that does refresh your recollection?
That John said it, yes.
Oh, you think that was John?
That's what it says on top of the paper.
Okay. Well, if I tell you that the transcript is titled in Mr. Fairchild's name, but you were actually also present there,
Yeah,
correct?
correct,
And
yes.
at times you jumped in that
Yes.
statement?
Yes.
So do you know whether or not this was a statement made by you?
Yes. It was not made by me.
Okay.
Yeah.
Does it accurately describe your view?
Yes.
Okay. So that you didn't have any reason for concern until after the child died?
Well, I wouldn't have called if I didn't have reason for concern, but yeah.
Is that what you said? No flags until after the fact, hindsight being 20/20? Or that's what he said,
Correct.
and you agree with that?
Correct.
Okay. I don't have any.
Regarding Mr. Easton?
No questions, Your Honor.
Whose responsibility is it to monitor the safety of a child and follow the protocols of protective service in terms of assuring a child's safety?
Are you asking me, is that my
Is
responsibility?
that your responsibility?
No.
Have you ever, or would you ever call if you were concerned about a child's safety?
No.
Objection leading.
Something that's allowed during the directly.
Did you believe that protective service was monitoring the safety of that child?
When she called, she said she was, so yes, I believe that she was.
Did you over the course of that month, after Ms. Minor had indicated to you about whether or not something verbally expressed to you that she wasn't taking medication, did your observations confirm that she wasn't, or that there was a possibility that she wasn't?
Yes.
Thanks.
That's it?
Well, just quick.
You testified
I can't hear you.
You testified there was concerns you had regarding the behavior of Ms. Minor, is that correct?
Yes.
And this was during late April, May 2016.
Yes.
Then why didn't you file another 3200?
I didn't need to.
Why?
You only have to file one.
And is there anything you could do subsequent to that?
I'm not filing.
As a follow-up to the initial 3200?
I filed the initial 3,200. Unless there was something happening different, I wouldn't call CPS again and file another one.
Okay. You also further testified that her actions never rose to the level of requiring her to be hospitalized. Is that correct?
Correct.
Okay. Now, one final thing. During the cross-exam by fellow counsel, you indicated that the statements that you read in the transcript was that of Mr. Fairchild?
I believe so. I don't recall. The full name is at the top of the transcript.
Okay, I'd like to show you the transcript one more time.
Sure.
Refresh your memory.
Sure.
starting at page 33 of the transcript. Question 12.
Thanks. Line 12, is that what you're saying?
Line 12. Now, looking at that transcript, do you recall testifying during that deposition?
Yes?
And is those statements that follow, are those your statements?
Yes?
You say page 33?
Yeah.
Yeah. Okay.
Okay. So looking at testimony that follows, 33, 34, 35, are those your statements, Ms. McCall?
33, 34, 35?
Yes.
Oh, page 33. To be very honest with you, both John and I were both doing the deposition. We were both talking, so some of this looks like what I said and some of it looks like what he said.
I want to ask you specifically, are those your statements that refer to not raising any red flags?
No, I don't think so. I don't recall saying that.
I'm sorry, I'm not. 32. Right, but I still don't see where you're talking about it.
Oh, I see it.
She starts there and talks.
I don't.
She starts and goes straight through. That's
All right. Yeah,
I think Ms. McCall.
yes, she's an objector. What would you call it? Okay, it's fine. I mean, it really doesn't make sense.
Nothing further.
Thank you, ma'am.
Thank you.
Yes, okay. You're making a motion, I don't.
We have no witnesses.
No witnesses.
Any argument as to how
Yes, Your Honor.
I anticipate.
I have argument as well.
Okay. Well, Your Honor, this case is, the charges involuntary manslaughter and child abuse second degree. So, Your Honor, involuntary manslaughter, we'll start there. The elements require specific intent to willfully disregard or specifically disregard their duties, Your Honor. There's a specific intent.
Or be grossly negligent.
The gross negligence, let me find it. The gross negligence in that, in involuntary manslaughter, Your Honor, is mentioned in People v. Giddings 169, Mishat 61631. And it starts with Rezac, People v. Rezac 224, Mish 106, 1923. And case law follows from there. And it outlines the element in there to support a bindo. First, you have to have the existence of a legal duty. So in this case, that has not been established, that you have to have, that there was any duty beyond what the CPS workers had done. Mr. Parks testified that they didn't violate any policies. The issue pertaining to this court is
That's different. You're talking about a legal duty. I don't think, I didn't anticipate that you would dispute that there was a legal duty.
Your Honor, the legal duty for involuntary
But what I
manslaughter.
mean by, maybe I should clarify, because we may be talking about two different aspects of legal duty. When I'm talking about legal duty, I'm talking about legal duty as it pertains to the safety of the child.
Oh, they have a duty in that regard, Your Honor.
All right.
But they didn't. But they would have to establish that duty beyond what the CPS worker's done in this case. Their duty is pertaining to the policies that are before them. They followed the policies, and according to Mr. Parks and Lynette Wright, they followed those policies specifically. It has to have, then the second element is the defendant's knowledge of that duty, but the third, defendants willfully neglected or refused to perform that duty. The evidence in this case shows that Ms. Brown, not only did she visit within 24 hours of the report, she went back a second day to check on food. She contacted the mental health agencies. The exhibits show that she tried to reach the father of the child while he was incarcerated, contacted the other father of the other children, and she was thoroughly investigating this matter. If she was doing nothing, there may be an argument, but they have to show that she willfully neglected, specifically intended to neglect this child, or specifically refused to perform her duty, and that hasn't been established in any capacity here. And then the next part of that element, Your Honor, is part of willfully neglect or refusal, is that she has to have knowledge that a situation existed that required the use of ordinary care to prevent injury. To do that, the prosecutor would have had to establish how the injury occurred, and that there was something Ms. Brown could have done to prevent it. That has not been established, Your Honor. Have the capacity, means, and ability to avoid the harm by use of that care. The prosecutor would have had to establish in some form or fashion that Ms. Brown had the ability to stop whatever happened to this child. We don't know what happened to this child. And also, Your Honor, to use ordinary care that is apparent to an ordinary mind that harm would result of such failure. In this case, the mental health worker just testified. She didn't see anything that would indicate to her that the child was in any type of danger. In fact, she said the child was well fed, healthy, played. The officer who was there with Ms. Brown at the scene, same testimony. The child was healthy, clean, and playing. So when you add those together, Your Honor, there is no way for the prosecutor to establish the duties or the elements of involuntary manslaughter. And we need to walk through.
I think that they would, and I don't mean to speak on behalf of Ms. Goldfarb, but I believe their theory is that she did have the ability to stop what happened by virtue of removing the child from the home, from that situation. But I understand the flip side of that argument is that she had no legal basis to do so. At least that's what we heard from the witnesses that testified so far.
Yes, Your Honor. And also, Your Honor, with the involuntary manslaughter, the crime before us, the medical examiner testified that he wasn't really sure what happened. He just said, since it was a child, you can't rule out suffocation. But he also dealt with the jurisdictional issue here. The medical examiner said the body was moved. It was placed in the bed, and under cross-examination, he said it could have came from anywhere, essentially. I asked him, did it come from Ohio? And he said possibly. I think we mentioned Canada. He had no clue where any crime occurred. His only testimony was that the body was placed there. We also asked him regarding sudden unexplained death in children, or in items that you can't explain when someone dies and you have a body that's been decomposed in the state that young Aaron Minor was. He testified that there was other things that could cause the death. His thing was you can't rule it out. Can't rule something out does not establish that there was a murder that occurred.
Certainly not your strongest argument. Go ahead.
Okay, Your Honor. But in this particular capacity, Your Honor, to get to the CPS workers, here you have a child that died. To get to them, the prosecutor has to show that they could have prevented it, they had a legal duty to prevent it, and they were able to prevent it. But also the prosecutor still has a jurisdictional issue. They have to show that a crime occurred for involuntary manslaughter, Your Honor.
I understand that too, but for probable cause purposes, again, not your strongest argument.
Well, Your Honor, when we talk about what transpired here, you have the medical examiner not knowing what happened. Then you have the maintenance worker saying the door was open. We don't know how or what happened to this child. The CPS workers, based on what's been put in evidence, did everything they were required to do pursuant to their policies. There is no testimony that says, from anybody, that says they did not follow their policy and procedures. So if they followed their policy and procedures and something happened to this child, it was nothing they could do to prevent something happening because they couldn't go beyond their policies and procedures. And we have to look at the scene when Ms. Brown showed up at the property. The scene there was she went into the property with the police. All parties involved, at least all that testified, was this child was okay. She went back the next day. No police involvement because Ms. Minor let her in. Her observation at that time, which is in the evidence through the exhibits, the child is okay, playing, doing what normal 3-year-olds do. The testimony from Ms. McCall, the exact same thing. All her observation was the child was doing what normal 3-year-olds do. No bruising, nothing that would suggest that this child was being any maltreatment. And Ms. McCall, who was the reporter in this, her only concern was that she wasn't sure Ms. Minor was taking her medication, so since she wasn't sure, she filed a report. But she didn't establish, her exact testimony was she didn't see any physical harm or any mental harm to the child. Ms. Brown followed up with them after she went out there. That's also in the reports in her records. Again, Your Honor, no physical, no mental harm to this child. So if there's no harm to the child, no threat to the child, and also, and when we talk about threat, we need to mention Mr. Park's testimony. He specifically indicated that the prosecution was applying the wrong standards, the wrong policies. His testimony was that once we see a child, one set of policies go into effect. But if we don't see the child, the policies that the prosecutor has presented, 713, come into effect. In this case, they saw the child. So the policies that the prosecutor is trying to apply to them are inapplicable based on Mr. Park's testimony. And Your Honor, then as we get to the next element is child abuse second degree. Again, the defendant had to knowingly or intentionally act to cause the serious physical or mental harm to the child. It's a specific intent for that crime as well. The prosecutor is trying to indicate that a duty that wasn't breached was the cause of child abuse for Aaron Minor. They haven't established any of those elements either, Your Honor. Specific intent means that they have to have some witness that could, or some statement or some testimony or some exhibit that shows Ms. Brown was intending not to act, that she willfully disregarded something, that it was willful and reckless or what have you. There hasn't been any testimony as to that. Actually, the testimony has been exactly to the contrary, that Ms. Brown did everything she was required to do and some. But there was an unfortunate thing that occurred with Aaron Minor, and it's as tragic as it is, and there may be some sense that somebody has to be blamed, but it's not Elaina Brown. She did her job to the letter. And so, Your Honor, we ask that Ms. Brown not be bound over on these charges.
In response, Your Honor, I'll adopt all of the arguments by counsel, and I understand the court's argument about the jurisdiction, but I do wish to at least place on the record that I don't believe that it's been established where the crime, if any, occurred. I think there was a homicide. I don't think it's been established there was a murder. And the reason I believe that is because the medical examiner's testimony was, I don't know where the child died, and I don't know when the child died. It could have been in about I think it was a 12 or 13-day period of time, with that time being split by the time that Deanna Meyer was there for the first part of it and not there for the second part of it. The medical examiner testified it could have been this, because I couldn't rule that out. It could have been suffocation, because I couldn't rule that out either. And there's no set of facts which makes one more likely than the other. There was no other medical evidence.
I believe I have a statement of the medical examiner indicating that the child died sudden infant SIDS,
Sudden infant
death syndrome. It's unlikely. But
obviously the court recalls that.
Probably couldn't rule it out. But the child at 3 years old?
I remember him indicating it was a possibility, and obviously the clerk has a memory of that. I don't specifically recall it, but obviously you do that it occurred. I think, I do recall him saying it could have happened in Michigan, it could have happened in Ohio. I would also point the court to the testimony of the maintenance worker who arrived and the door was unlocked. So again, there's no evidence as to any connection that Deanna Minor had with this child or anyone else. It could have been anyone else. There was reference to the mother. I mean, there were other people that had access. So, I understand the court statement. It's not our strongest argument. I would like it based, I'd like it placed on the record here. I do think that the bigger and more important missing elements in the prosecution's case is the evidence with regard to the specific elements of the involuntary manslaughter. First of all, with its legal duty to Aaron Minor. I think we all agree that Child Protective Services have a duty. They have a duty to follow the law. However, their duty is restricted by the child protection law, which only allows them to step in and investigate cases of alleged abuse and or neglect. So in this particular case, as we started out, I believe the prosecution's theory, not to speak for them, but I believe that their theory was that once the complaint was made on April 20th, there was a continuation of information that was flowing to CPS by Elaina Brown, and that she failed to act on that. I think what we just heard from Ms. McCall was an initial complaint was made on May 20th because she had a concern that Deanna Minor may not have been taking her medication and that she was acting perhaps erratically, or she had some concerns about her behavior. However, and this is the big point, those concerns could not be tied to a concern for Aaron. And that is the big point. She never saw any signs of abuse or neglect. What she said was, if Deanna Minor wasn't taking her medication, then there's a possibility that she might not be able to care for her child, but she didn't have any evidence of that, and that's a huge jump. And I submit to the court that if Elaina Brown had come before this court or any other court with a request to remove a child based on the allegation that a mentally ill person might not be taking their medication, and if they're not, then they might not be able to take care of their child, that certainly doesn't raise to the level of removing a child from a home. So when I say that I was going to argue that there was no legal duty, obviously they were still in the investigation phase of their case. They obviously had a duty, but they certainly didn't have authority, according to the child protection law, to do anything with that child. So when Ms. McCall testified, if there was a mental health issue, then what would have happened is that they would have made a referral to CMH. What CMH? Community Mental Health. That's Tracy McCall. So there already was a referral made to CMH. She already was working with CMH at that point. So again, when we're talking about a legal duty, there was nothing that Elaina Brown could have done at that point.
In addition to that, she was following up because the call that was made to one of the team members was initiated by Ms. Brown.
Well, Ms. Brown was the one who initiated, and that was another one of my points. It wasn't CMH calling CPS saying, oh, we have more and more concerns. It was Elaina Brown following up and doing her due diligence in this case to follow up to say, what else do you have? And if the court will recall, in the specific exhibits, I believe it was 8 and 9, the two reports, the two sets of the CPS reports, it details that specifically on May 6th and May 12th, Elaina Brown said to the workers, do you have any evidence of abuse and or neglect? And they responded by saying, no. And there was a conversation. Look, I understand that there's something not right here. However, I don't have any authority to act. And Colin Parks, the person who writes the policy and makes sure that the policy is in compliance with the law, there's no violation here. I hope the court remembers that. I do remember that. He said there was no violation of any policy here. And I would argue, by extension, obviously no violation of the child protection law, since the policies mirror the child protection law. So I don't believe that she had a duty to keep the child safe in all circumstances. Of course, we would love for that to be the case, but that is obviously not what can happen here. While I understand the argument that, setting aside that I don't think she had enough to ask for removal, if Elaina Brown had asked for removal, I think there's an argument from the prosecution that that could have prevented a homicide from taking place or a murder. If their theory is that Deanna Brown committed a murder, then I would indicate that perhaps it could have. Perhaps it could have been an intervening cause. Perhaps it might have just resulted in a delay. Perhaps if the police officers had picked up Deanna Minor on an outstanding warrant, that would have been an intervening cause. Perhaps if Tracy McCall or John Fairchild would have filed a petition for involuntary hospitalization, that could have been an intervening cause. But all of these presuppose the fact that that could have been done, however, the authority just wasn't there. And for the prosecution to argue that Elaina Brown and Kelly Williams are guilty of involuntary manslaughter, there's nothing different between them and Tracy McCall, who said, yes, I had the ability to hospitalize Deanna Minor, but I never came to believe that she was a substantial risk to herself or someone else, so I couldn't, and I didn't. So again, if the theory is going to apply that Elaina Brown and Kelly Williams should be sitting here, then so should Tracy McCall, which is, it's ridiculous in my opinion, because they didn't have the ability to act. Now, I will follow up with other counsel's arguments about willful, being specific intent, and then having specific knowledge. But I think there's one other aspect, and that is, and this is the glaring missing piece of the prosecution's case, that the court is not supposed to bind over unless there's evidence as to every element. In this particular case, the element that's missing is that Erin Minor died as a direct result of Elaina Brown and Kelly Williams' actions. Direct result being their actions were the cause of Aaron Minor's death. And there's nobody that can say, there's no evidence that even can be stretched that Elaina Brown's actions were the cause of Aaron Minor's death or Kelly Brown. And in regard to Kelly Williams, the only different argument that I have, other than Mr. Eason, is that there's no evidence that Kelly Brown was aware of all of the facts, and that is a specific element that the defendant be aware of all of the facts that make up the circumstances that in a reckless disregard of the likely result, that likely result would occur. And there is no evidence that Kelly Williams knew all of the facts. The testimony was that she was supposed to sign off on the report. We know that the report wasn't closed until August, well after the child had died. In addition, I think that with regard to the child abuse law, the same arguments apply to element one, that being that the parent or guardian or had care or custody or authority over the child. Again, that authority is limited by the child protection law. They couldn't, if they had wanted to, they couldn't have gone in and asked for a removal because there was nothing. They saw nothing. They saw no evidence of abuse or neglect. They saw no evidence of a substantial risk or harm, nor did the police officers. So we have 2 police officers that were there, 2 CPS workers, and now a community mental health worker saying, yes, we understand this woman had mental health issues. However, not one of them acted. The police had the authority to remove if they saw anything unusual, and you heard from Officer Thurston that I saw nothing. The child was fine. I saw no abuse of substantial risk of harm or abuse or neglect. And that basically is the same thing that every other witness has testified to. This is, in my opinion, a very overbroad application of the law, very dangerous application of the law to try to connect the act of death and say that it was specifically caused by Elaina Brown's inaction and Kelly Brown's inaction is not what the law intended in this case. And I ask the court to dismiss counts 1 and 2 of this case and refuse to bind over on both felony counts.
In the interest of not being here to all eternity, see if I can direct where the court has some concerns. I would like for you to address as it relates to one reverse order, as it relates to defendant number 2, Ms. Williams, starting with count 2, child abuse in the second degree, and then we can work your way.
Your Honor, the child abuse in the second degree requires knowing or intending to do an act likely to cause serious physical harm. The protective service worker is responsible not only for removing a child, but for monitoring a child. The protective service worker is, the law requires they monitor. The protocols require a complete investigation be completed within 30 days, that all of the elements of an investigation be completed. These were, and that the supervisor sign off. We have it's difficult because the protocol has been admitted, and I really urge the court to look at it. I was prepared to argue the protocol and what they're required to do by protocol in English language, and the amount they completed, she completed, Elaina Brown completed, which is required to be monitored by your supervisor, was 41%. The argument here is that that Elaina Brown and or her supervisor, that the 2 of them are required to do anything after an initial visit. What they're required to do is to assess the safety of a child. The argument is that they can ignore the child, not see him somehow, and that allows them to assess safety. And, Your Honor, I would indicate, when you look at the records, even they...
See, I feared this, and that's why I wanted to direct you to count 2. I wanted you to speak specifically as to child abuse in the second degree and defendant number 2, Ms. Williams.
All right.
People's theory.
All right. She is required to make sure that an investigation is done within the 30-day period, completed, and that the worker who's doing this investigation has...
Okay, so the investigation began when?
In April 22nd, or April 20th, excuse me.
April 20th. So...
And it was never closed out. According to Law&Crime, all they have to do is leave it open. They don't have to actually do anything with regard to this minor.
Well, that's not what he said, testified to. He testified that she did do some things, but he couldn't speak as to exactly what without referring to some records.
All right.
And then we find out that she was making phone calls. And
She was
following up, she called Tracy McCall, or one of the people on her team.
And if you look, Your Honor, at the actual protective service workers' records in this case, the actual records that are kept on what she said on May 12th was what Elaina Brown recorded as the conversation on May 12th. And hold on a second. And this is the court. This is the court's exhibit. She said on May 12th, Miss Brown, that she's erratic, unpredictable. This is Elaina Brown's own records of the conversation. So even with these warnings, and whether Elaina Brown is sitting at your desk and initiating a conversation where you get additional information about the child being at risk and ignore it is...
Okay, and let's be careful how we use that terminology, at risk, because witness after witness that took the stand tried to make clear to us that there's a difference between risk factors to be considered versus a child being in danger.
And threatened harm is defined in their rule as is found with a parent.
No, but she said at risk. And now you want to interchange threat and harm.
Well, okay.
But we can't do that. See, you're not a social worker, I'm not a social worker. They speak their own language.
They speak English, Your Honor.
Yeah, I know they speak
Imminent risk means that a risk hanging over your head. That's how they...
Who testified that the child was at imminent risk?
The testimony, the evidence, that's the problem. You have to put together, and I was prepared to do it, the records with the information they had. If you put together the records that they have continuing information that she's not taking her medication, that she is, according to their own, hostile, aggressive, inconsistent, unpredictable, erratic, and volatile.
Towards them?
No.
Yes, because I asked the witness myself, and I said, was any of that behavior directed to the child whatsoever? And she said no.
And whose responsibility, though, when you have this information, and that's where they're grossly negligent, and that's where they did not follow their duty. They had information that this person was deteriorating, had these behaviors. It's only their responsibility to investigate what happened, how safe Aaron is with someone who's acting out in that way. Not anyone else. They can try to switch the responsibility. They can try to equate substantial risk in a hospitalization to the risk to a child, a vulnerable child of 3 years old, in a situation where there is no social support, where there is a mother with a history of mental illness, where nobody is monitoring. That's why Protective Services has the duty they have. They can't put it on the police. They can't put it on someone else. Their responsibility is to monitor the child, to get the information and see if he's safe. And instead, what they did was gather information and do nothing. That is not assuring safety of the child. That's why they were grossly negligent. That's why they committed an act likely to cause serious physical harm. Because
when you say do nothing, what exactly do you mean? Because there was an initial visit, there was a follow-up visit, there was a letter sent, there were calls made.
a letter sent that indicated that they couldn't get a hold of her. So that would...
Okay, so again, if they're saying,
that,
I can't get a hold of you, I'm sending you a letter because I can't get a hold of you, that in and of itself says that somebody's trying to get a hold of someone.
it says that that is not going to assure the safety of Aaron.
Okay.
And
Now, wait a minute, and let's talk about that just for a moment, because, again, this is where we start to confuse what are the appropriate steps pursuant to their policy. Because it was Mr. Parks that indicated that once a case is initiated or so forth, and there's been no communication, then that triggers a different set of steps versus whether there has been some communication or some contact with the person. In this case, we have contact, right?
We have contact. The actual protocol, Your Honor, says that you must either call the police, do not either call the police or file this. You must. If they're uncooperative, which she was, based on that letter, we know she's uncooperative because they're not responding according to them. And when you have a parent who is uncooperative, and there is...
The policy that he read indicated stated when there was no contact whatsoever, that would cause some imminent risk to the child's safety. You know what, Your Honor? That was your witness. I didn't call.
But that's correct. But I can't make a witness who is out to protect, brought to you by the state of Michigan, out to protect protective service workers who are negligent. Well, I agree. To admit the policy, and he can say what he wants, but the court has to look at the evidence. And the court has to look at the policy. The court has...
This sworn testimony is evidence that she presented. As well as every other witness.
And the court can look, that's correct. The court can look at whether that is credible testimony or whether it is designed to change the words of a protocol to meet the needs and to benefit workers instead of children.
Where did I get all that from?
Well, you can look at what was going on with Mary Mine and look at the protocol, the actual protocol, the written word. Not what he thinks he wants it to mean now, because he said, well, now I've looked at it. He actually said he changed his mind about what it means. He said, oh, yes, I did equate threatened harm with imminent risk. But now I don't think so. And I went to show him his transcript, and he said, okay, I know, but now I don't. This was a perfect example of a bureaucrat who does put out these records, who is committed to the agency and not the people they're here to serve, not the children that he has to serve, and that these workers are required to serve. And we heard the training is that mental health, they don't have to, this is not a question of guilt with regard to Deanna Minor. This is a question of, was she capable, from the information they had, of caring for a vulnerable 3-year-old child without social support, without any monitoring, without anybody looking in on Aaron, without assuring his safety. And yes, so she called and got more information that Miss Minor was mentally ill, was deteriorating, was all of the adjectives that they recorded in their records, and took no action. And they are required to do a complete investigation within 30 days. I can tell you that if you go through the protocol, they didn't do it. That they know, they both know, that a complete investigation does not mean not seeing the child. In fact, according to Elaina Brown's own record, she said she went there on May 23rd, but couldn't get in. Knocked, she says. I don't know what door she knocked on, because the testimony is you can't get in. And did nothing. Did nothing. She sent a letter indicating that she was uncooperative, and did nothing. She got additional information that her mental health was deteriorating, and mental health, based on their own protocol, is a danger to a child. Not because it's Miss Minor's fault, but physical deterioration in health can impede your ability to parent, for sure. And then there's all of the other.
See that no one has testified that they observed anything like that. We're talking about possibilities. Just because someone does not take their medication does not mean, in and of itself, that they have an inability to parent.
Your Honor, nobody has testified because nobody had a responsibility to see this child. That's the thing. Okay, don't see him and then say, well, nobody said it. Because only...
Saw him.
No, nobody saw him from May.
The same witness who testified that this witness was exhibiting aggressive behavior and grandiose, whatever it is, said she also saw her with the child.
Not after April 27th. No.
This was in May.
No. The records, her records, the protective service records state.
I'm talking about Tracy McCall.
Tracy McCall did not testify that she saw her in May. She said she did not know when they last saw her. That was her testimony.
Okay, so we're only talking about 2 months here. April and May.
And they never, and it says, Miss Brown's own records, Mr. Fairchild has been unable to make face-to-face contact since April 27th. That is the information they had and didn't act on. That's why the records are so important. It's that on the May 12th entry, they had that information. No, nothing. And so we're talking about all of that, when you look at the factors that they're supposed to consider, and as I mentioned, social support, the ability to parent, the history. She's on the central registry. She is by all allegations not taking her medication. They're trained. Look at the training, Your Honor, that says mental health can, in fact, be a detriment to the ability to parent. No, this is the only response that you can't put up somebody to say, well, nobody saw him and nobody saw her, so therefore he wasn't at risk. Every single sign shows that this child was at risk, and it's their responsibility to see him, to assess his safety during an investigation and on, to have what called this case in was a report that the child was at risk because of his mother's mental health concerns. And as it went along, there were more concerns. And as it went along, there was a possibility of losing housing. And as it continued, they got information from the one other adult. And as it continued, they were able to get more information. But getting information does not assess safety. And especially when the information you're getting is that that this mother's mental health is deteriorating, your protocol and training is such that that represents a risk. There are two sets of records that were admitted. I'm urging the court to look at them, to see the difference if they played catch-up in the first step that we had to get by investigative subpoena, and the second step that we got later in the court in this case. I am asking the court to look yourself at the protocol.
I'm going to review all the exhibits.
Okay. Look yourself. Does it say that you have to never visit the child again if you saw him once? Nowhere. Nobody pointed it out. Whether Colin Parks wants to say that, it's up to the court to determine whether that's credible, whether that makes sense, whether it makes sense in light
You're
of...
repeating yourself.
Okay. Yes. The manslaughter, I agree with counsel with regard to the Giddings case, and gross negligence is willfully ignoring what happened here. The child abuse is knowingly or intentionally committing an act. They knowingly and intentionally did nothing to follow up during the 30-day period. And yet, it is Ms. Williams' responsibility as a supervisor to assure that it's done. You heard from Lynette Wright. Assure that it's done. Every part of it is done. There is a checklist of the things that are supposed to be completed in the 30-day period. And I did one, which was commence investigation within 24 hours. Assess child safety and service needs of the family. Nothing was done, despite the training, to assure that this minor was taking her medication, because their training and their protocol indicates that if the parents a child who is vulnerable and a deteriorating mental health can be a risk, and they're required to assess it, but assess it, see and monitor. And Ms. Brown actually told Ms. Fairchild that she was going to monitor. She was monitoring, and she was not. So, to now say, Ms. Brown told the witness, Tracy McCall. So that now you're going to say, well, Tracy McCall didn't do anything. Tracy McCall's job is if there's a substantial risk of harm. They haven't been able to see this kid. But Protective Services has the ability, and in fact is instructed under the protocol, when a parent is uncooperative and there is an imminent risk, which is defined in Webster's Dictionary as a risk hanging over someone's head of harm, and it's defined in their protocol. Mental health problems can be a threatened harm to your child, that they are required, it says they must call the police for a safety check. They knew full well how to do that. They knew full well, and the police respond when vulnerable children are at risk. And file a petition for the child to be observed. A half an hour or even an hour of observation does not assure the safety, and it is grossly negligent to not continue to monitor a child. Whether you initiate the information or not, you have information that this parent is deteriorating, that there's nobody's helping this child, nobody's seeing him. That's what the information they had. That's what was grossly negligent. That's what established the risk. When they had the information and they didn't act for a vulnerable 3-year-old, they are the only ones who stand between these children and abuse. You don't look for a child to be abused to act. You look for risk factors to act. And they established the risk to this child. They obviously lost contact with him. They knew that nobody was seeing him, and they failed to act at all. It is Ms. Williams' responsibility to make sure that investigation is proceeding to a closing out in 30 days. It is likely, Your Honor, under child abuse statute, it is likely that a vulnerable child in this situation with ongoing mental health service concerns and no support anywhere, it is likely that there is going to be serious physical harm. It is appropriate that when workers, we are called upon, when police are grossly negligent, to prosecute them. When people who don't keep clean water, prosecute them. When EMS workers don't respond, prosecute them. When a worker leaves a vulnerable child with ongoing information in a situation where there are very protocols set, it is likely to be, there is a possibility of risk. And not monitor, not check on him.
Repeat yourself.
Okay. Well, okay. And I understand, the court asking me to respond, but you know, this is a case where you have a timeline. This is a case where you actually have records that interplay with one another, testimony that is disingenuous and makes no sense in light of what's written. And Colin Parks can come here and say whatever he wants. I just... All right. Then I will be done. Thank you.
I need the exhibits. And I would be prepared to make a ruling on the bind over as early as tomorrow morning. First thing tomorrow morning, and it would take no longer than 2 minutes. Is that good for you, Ms. Goldfarb?
Yeah, I have obvious, I'm sure other places, but I'll make it work.
10
Based
minutes.
on them, yeah.
What's the time, Robert?
9 o'clock? 9 o'clock sharp. I'll start right at 9 o'clock.
All right, thank you, Robert.
Thank you.
9 o'clock?
Yes.
All right. I need the exhibits.
If I could just have one moment, Your Honor, to make sure that...
And we'll show it to the defense before we decide.
Okay. As long as they finish it.
No, I know, that's why I'm going to show it to the defense.
We can either adjourn or we can not pay later.
So you put it over till tomorrow?
Yeah.
So you available tomorrow? Last one, Sherry. Oh, and one.